but I was here in the Norfolk Superior Court today, completely unrelated to Mr. Carney, my client, as you know, in the other matters. And I was here today on the matter of Commonwealth versus Tylee Curry for a motion to suppress.
Which is a case that I am in the middle of that motion to suppress with you.
Exactly. And I actually figured that we wouldn't do the motion and get a date. But I was fully focused on that matter and had no notice whatsoever that the Commonwealth was in the Reed matter, was seeking to exclude my client as a journalist from this court. The first thing is that, and I know the court has a job to do in terms of ruling on this motion, and that's fine. And I asked that the ruling be that it be denied on procedural grounds. The procedural grounds are, Judge, that there's been no service of process whatsoever on a case where the government is seeking to essentially trample all over my client's First Amendment rights as a journalist. On 15 minutes notice. I know you gave him, I think, 15 or 20 minutes.
It's more than half an hour, but I understand.
All right, well, you get the point. So, it's not something that I can process and absorb and make any sort of cogent arguments on the merits of the motion on that time period. And I'm sure that the court respects that. I'm trying to address it as best I can, but I think that the procedural issues here should control. And here's the procedural situation, Your Honor. That the government filed this 6-page motion. There's a footnote 2 that refers to them serving this motion on May 8th to the Associated Press. Why they couldn't just pull up my email and serve me is an open question that I'd like an answer to in open court. So they can serve the AP 2 days ago, but they can wait and not even serve me with the motion when I get here to court today on a completely unrelated matter, I might add. So there's some funny business going on here, and there's been nothing but funny business from where I sit from the Commonwealth on Mr. Carney's matters. And here we go again. So I don't appreciate that from counsel, from the Norfolk County DA's office, number 1. Number 2, Your Honor. Mr. Carney has covered this case and written about 350 news articles on this case. He has developed evidentiary scoops on this case that have added to the quantum of evidence in the matter. He's never caused a problem. He wishes to be in the galley of journalists like everyone else and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Carney. Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata ×2. Judge Krupp in this very court addressed this exact issue about Mr. Carney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. All these people, this was adjudicated fully with the Special Assistant DA before Judge Krupp, and Judge Krupp ruled against the Commonwealth. Judge Krupp said that Mr. Carney was able to be in the courthouse covering this case regardless of any of these witnesses in the stay-away order. The stay-away order was exempted from Mr. Carney. Mr. Carney's presence in the courtroom, rather, was accepted from the stay-away order. So this is done. This has been adjudicated. It's been adjudicated again, Your Honor, by Judge Pomeroy across the street in the district court. One of these people associated with Mr. Carney's detractors, Ms. Katani, has taken up with the Commonwealth and sought charges and sought a restraining order against my client. And Judge Pomeroy recently, as recently, I think it was a couple of weeks ago, we were across the street, Your Honor, seeking to vacate the order under the doctrine of unclean hands because this plaintiff keeps trying to contact my client while under a restraining order. Putting that aside, the ruling in that matter, Judge, was another ruling in support of Mr. Carney's First Amendment rights. It was another ruling that said Mr. Carney was not subject to the restraining order in any court of the Commonwealth. And the reason we brought that motion, Your Honor, was because these same witnesses that the government here is again trying to advocate for their own personal issues, those same witnesses somehow took up with this plaintiff across the street, Ms. Katani, brought her to court here in prior Reed proceedings to kick out Mr. Carney because at the time she had an operative order against him. And Mr. Carney, to his credit, got up and left and got out of here. And that situation was what we addressed across the street with Judge Pomeroy. He agreed with us and said, you can go to court, you can cover this case. So number 2, litigation number 2, this has been established. Mr. Carney followed all proper channels. We worked with the SJC media office. He has a press pass. He's doing everything in accordance with all of the rules and regulations that are in place. He's been harassed, and we have it on video, by other so-called journalists on this case at the steps of the courthouse. And he just wants to be here. He doesn't want to be an issue in this case. He wants to sit here and cover the case. He's done his job. He wants to watch the trial unfold. And he has an absolute fundamental First Amendment right to do so. Within the confines of this courtroom and within the confines of time, place, and manner restrictions, he's followed everything, and he's here. We've gone through all of these hurdles, Your Honor, and Mr. Carney triumphed, as he should, because it's the First Amendment that needs to triumph here, not any particular person. And that's what he's doing. And there's absolutely no reason for the government to sneak behind my back to interfere with his First Amendment rights. It's outrageous, and on procedural grounds, I ask you to deny the motion for all of those reasons. And if the court has some hesitancy to do so with respect to these procedural issues, I ask that you set a date give me 7 days or so that I can properly respond to this motion on the merits of whatever's in these 6 pages of the motion that I haven't been able to look at. So thank you for hearing me, Your Honor.
All right, sure. And you wanted a response to your question from Mr. Lally on why you were not served, but the Associated Press was served.
That's correct.
So if you talk about that in the procedural part of this, Mr. Lally?
Yes, Your Honor. Simply put, Mr. Bradel, neither Mr. Bradel nor Mr. Kearney are parties to the case. I can't presume that Mr. Bradel's representation on